Imagine waking up one morning, opening your mailbox, and finding a letter from the Social Security Administration, and this letter is not asking for money back. It is not threatening to reduce your benefits. Instead, it is telling you that a decision made in Washington, D.C., a decision made by 9 of the most powerful judges in this country, has just shifted the balance of power away from the government and toward you. That sounds almost too good to be true, right? But here is the thing, something very close to that actually happened. And most people collecting Social Security, retirement, SSDI, or survivor benefits right now have absolutely no idea it occurred. We are talking about a Supreme Court ruling so significant that legal experts are calling it the biggest shift in federal agency power in the last 40 years. And if you depend on Social Security in any form, this discussion could be one of the most important ones you hear this year. So let us talk about what really happened, what people are saying, what beneficiaries are feeling, and honestly, what this could mean for millions of Americans going forward. For about 4 decades, there was a legal doctrine quietly operating in the background of almost every federal agency in America. Most people never heard of it. Most beneficiaries never knew it existed, but it affected their lives in very real and very direct ways. It was called Chevron deference, and the basic idea behind it was this. When Congress passed a law with language that was a little ambiguous, meaning not completely crystal clear, federal agencies like the Social Security Administration were given the authority to interpret that language themselves. And here is the part that really matters. Courts were told to side with the agency, not with the individual, not with the claimant sitting across the table trying to get their benefits approved with the agency. Think about what that meant in practice for someone trying to fight a decision. You are already dealing with a complicated system. You are already stressed, possibly sick, possibly watching your savings disappear. And on top of all that, the law was essentially set up to give the government the benefit of the doubt before you even walked into a courtroom. That was the reality for 40 years. And then, in the summer of 2024, the Supreme Court changed it. The case is called Loper Bright Enterprises versus Raimondo, and the court's decision was sweeping. Federal agencies, including the Social Security Administration, no longer get automatic deference when their interpretation of a law is challenged. Courts now have the independent authority to look at what Congress actually wrote, what the law actually says, and make their own determination. The agency's word is no longer the final word. Honestly, when I first sat with that for a moment, I had to think about what that really means on a human level. Because for beneficiaries, this is not just a legal technicality. This is a structural change in who has power in a dispute between you and the federal government. A lot of beneficiaries believe the system has always been stacked against them, and looking at 40 years of Chevron deference, it is hard to argue they were completely wrong. But here is the part that not enough people are talking about. This ruling does not just affect future cases, it is already creating ripple effects in courtrooms. Right now, today, across multiple federal circuits. Let us make this real. Because abstract legal doctrine only matters when you connect it to actual human situations. Think about the overpayment crisis in 2023 and into 2024. The Social Security Administration sent overpayment notices to hundreds of thousands of beneficiaries. Some of those notices demanded repayment of $10,000, $20,000, in some extreme cases even more. Money that people had already spent in good faith on rent and groceries and medication because they had every reason to believe their monthly payments were accurate. Under the old system, if you challenged one of those overpayment notices in federal court, the judge was essentially predisposed to side with the SSDI calculation method. The burden was incredibly heavy on the individual. Under the new framework that Loper Bright has established, a judge hearing that same challenge can now look at the actual statute and ask a genuinely independent question. Did Congress actually authorize the SSDI to calculate and collect overpayments this way? That question now gets a real answer from a neutral party, not just a rubber stamp from the agency itself. Some people are starting to wonder whether this could open the door to large-scale challenges against overpayment collection practices that have caused serious financial hardship for some of the most vulnerable people in this country. And honestly, that speculation is not coming from nowhere. Legal advocates across the country are already building cases around exactly this argument. There is another group that needs to hear this conversation, and that is everyone who has been denied Social Security disability benefits. The SSDI has historically used its own agency-developed definitions to determine what counts as a disabling condition, what counts as an inability to work, what counts as enough medical evidence to approve a claim, and under Chevron deference, courts were inclined to uphold those definitions because the agency had developed them. There is growing speculation among disability attorneys that the Loper-Bright ruling could give denied claimants new legal footing to challenge those definitions, to argue that the SSDI's interpretation of what constitutes disability under the Social Security Act is more restrictive than what Congress actually intended the law to say. If you were denied SSDI or C in the last 2 or 3 years and you stopped fighting because it felt pointless, this might be the moment to revisit that decision. I am not saying it is a guaranteed outcome. Nobody can promise that. But the legal landscape has genuinely shifted, and what did not have legal merit 18 months ago might carry real weight today. What happens next in those courtrooms could surprise a lot of people. Here is where I want to zoom out for a second, because this ruling exists inside a much larger story that millions of seniors and disabled Americans are living every single day. We are talking about people who are already stretched thin, grocery prices that have climbed and never quite come back down, rent that consumes a terrifying percentage of a fixed monthly benefit, prescription costs that force real choices between medication and food, and a Social Security payment that, despite COLA adjustments, has struggled to keep pace with the real inflation that beneficiaries actually experience in their daily lives. The financial pressure on this community is not theoretical. It is the reality of tens of millions of households, and into that reality comes a Supreme Court ruling that could possibly shift some power back toward the people navigating that pressure every single day. A lot of beneficiaries are feeling something they have not felt in a while when they hear about this ruling, and I think that feeling is cautious hope, not blind optimism, not celebration, but the quiet sense that maybe, just maybe, the system has a crack in it where light can get through. Now, the Social Security Administration has not come out with a dramatic announcement saying everything is changing. That is not how federal agencies operate, and honestly, it would be surprising if they did. But behind the scenes, the SSDI's legal team is actively monitoring litigation related to this ruling across multiple federal circuits. That is not nothing. That is an agency watching carefully because it understands the implications. And here is something worth sitting with. The SSDI's own policy manual, which governs how the agency operates internally, is under review in light of recent court decisions. Dozens of standing policies and procedures are being examined. That process is quiet, it is slow, but it is happening. Some believe the real changes will not be visible for another 1 to 2 years, as cases work their way through the federal court system and establish new precedent. Others think we could see significant policy shifts much sooner, particularly around overpayment collection and disability eligibility standards, if courts begin ruling consistently against the SSDI's existing interpretations. The way I see it, the timing of all this matters enormously. We are heading into a period where the conversation around Social Security's long-term funding, benefit levels, and eligibility rules is already politically charged. Layering a major shift in judicial oversight on top of that conversation creates an environment where things could move in ways that are genuinely hard to predict. If this discussion has made you think about your own situation, there are a few things worth doing this week. Log into your My Social Security account at ssa.gov and go through your earnings record and benefit history carefully. Errors exist. They are more common than the agency would like to admit, and under the current legal climate, you have stronger grounds than ever to push back on mistakes. If you have an open overpayment dispute, or if you were denied disability benefits and still believe that denial was wrong, consider consulting with a Social Security attorney. Most of them work on contingency, meaning you pay nothing unless you win. The NOSCR directory at noscr.org is the best place to find a qualified representative near you. And if you receive C, contact your state's Department of Social Services and ask directly whether you qualify for a state supplemental payment on top of your federal benefit. Many people are leaving real money unclaimed simply because nobody told them it existed. Here is where I land on all of this. The Loper-Bright ruling is not a magic solution. It is not going to instantly fix a system that has frustrated and failed millions of beneficiaries for decades. The legal process is slow, the challenges ahead are real, and there will be setbacks along the way. But something has genuinely changed. The automatic advantage the government held in every courtroom dispute with a Social Security beneficiary is gone. Courts are now required to think independently, and that independence over time could reshape how this entire system operates. The real question now is whether this legal shift will translate into real relief for the people who need it most, whether denied disability claimants will finally get fair hearings, whether overpayment victims will get justice, whether the C asset limits frozen since 1989 will finally face meaningful legal challenge, or whether the system will find ways to absorb this ruling and continue operating largely as it always has. Millions of people are watching, millions of people are waiting, and honestly, so am I.